The impact of Brexit on day-to-day compliance obligations under the GDPR for businesses that are operating in the UK is likely to be relatively limited. Although the UK will cease to be subject to EU law from the end of the Brexit transition period, it is nevertheless clear that almost all of the day-to-day compliance obligations that currently affect businesses under the GDPR will be unchanged. The reason for this is that the UK's Data Protection Act 2018 effectively transposes the GDPR from EU law into the laws applicable in the UK, and therefore businesses will still be subject to the same obligations they have at the moment, like maintaining privacy notices and ensuring that they have valid legal bases for processing, and ensuring that they keep appropriate records of those processing activities. However, Brexit is likely to cause a number of practical changes that will affect the approaches that businesses take to data protection in the UK. First, and perhaps most obviously, is the fact that the UK Information Commissioner, the regulator in the UK, will no longer be part of the European Data Protection Board. Tied to this is the fact that if you have a main establishment for data protection purposes in the UK, then you will no longer be able to rely on that main establishment mechanism after the end of the Brexit transition period. Either your UK business will have to find another main establishment elsewhere in the EU, which may require the very real and expensive transfer of decision-making processes into the EU, or it may mean that you don't have a main establishment at all, which may mean that you have to interact with a large number of EU regulators depending on where it is you are doing business in the EU. In addition, any UK-based business that is offering goods or services to individuals in the EU or is monitoring their behaviour may need to appoint a representative in the EU for GDPR purposes. It's also worth bearing in mind that cross-border data transfers are going to be affected by this. For its own part, the UK government has indicated that it has no intention of prohibiting transfers of personal data from the UK into the EU, and it has also indicated that it will maintain recognition of existing EU adequacy decisions. So it will still be lawful to transfer personal data from the UK to Japan and Israel and New Zealand and so on. However, EU businesses that are sending data to the UK will face transfer restrictions much as they face when they are transferring data to third countries in general. This means that if you have subsidiaries or business counterparties who send personal data to you from the EU, those parties will likely need to implement transfer mechanisms unless the UK is granted an adequacy decision. Assuming that the UK does not receive an adequacy decision as part of any trade negotiations, this may mean that your counterparties in the EU will require you to sign up to data transfer agreements in order to enable them to share data with you.